Hello everybody, my name is Average Election Enjoyer today on April 29th of 2026. And earlier today, big news, a big occurrence happened that, of course, if you're politically engaged like many of you are, you may have heard the Supreme Court limits the Voting Rights Act in a 6-3 ruling, so based upon party lines. Now, it didn't, it eroded the impact of the VRA, however, it did not dismiss Section 2. The consequence is somewhere in between. A lot of people are describing it as sort of a dead document where it's still on the books. However, as we will see later, they very much so restricted how it can be applied and basically made it not impossible, but impossible in the current with the current court and how they're going to be um, utilizing the definitions of Section 2 for it to actually remove a district, at least in all likelihood here. And the question was a case called Louisiana versus Callais, which raises question about the legality of having two majority black districts. So this was a case on majority minority districts here. And for the majority, Samuel Alito said the evidence of racial disparity drawing earlier maps was too weak to justify the use of race to draw the new map there, ruling it an unconstitutional gerrymander violating the plaintiff's constitutional rights here. As you can see, all three liberal justices, in fact, dissented, written by Justice Elena Kagan, in a somewhat fiery dissent, though, stating a state without legal consequence can systematically dilute minority citizen voting power. Majority does not announce today's holding that way, understated and antiseptic, saying the updates eviscerate the law and amount to a demolition of the Voting Rights Act. So a very fiery dissent from the three liberals on the Supreme Court. So if we look at the actual ruling here, which has been posted as of today, we can sort of go through some of the key points. This is the syllabus. This is going to be a brief sort of description. Here, this is the held opinion. Because the Voting Rights Act did not require Louisiana to create an additional majority-minority district, no compelling interest justified the state's use of race in creating SB 8, and that map is an unconstitutional racial gerrymander. That is the 6-3 decision that you can see. In this sort of syllabus here, we can see how they are sort of breaking down their tests to determine if it fails that second part of the Voting Rights Act. The first is Jingles, I believe, precognition is that a community of minority voters must be sufficiently numerous and compact to constitute a majority in a reasonably considered district. Plaintiffs cannot use race as a districting criterion in drawing illustrative maps, and illustrative maps must meet all of the state's legitimate districting objectives, including traditional districting criteria and the state's specified political goals here. To satisfy the second and third precognitions, voting must be voting by the minority and racial bloc voting by the majority. The plaintiffs must provide an analysis that controls for party affiliation, showing that voters engage in racial bloc voting that cannot be explained by partisan affiliation. This is saying that the voters are voting, as I said, racial bloc voting, not explained by partisan affiliation. So it can't be Democrat or Republican in terms of the racial voting bloc. It's got to be voting based on like the race as a whole there. And the third is on the totality of circumstances. Evidence must be on evidence that has more than a remote bearing on what the 15th Amendment prohibits, present day uh, intentional racial discrimination regarding voting there. Um, and so this case doesn't get rid of the second section of the VRA. It does, however, update that framework, basically the test for that. Um, and it is going to see, this is going to be the most important part of this sort of summary or this syllabus. At every step of the Jingles framework, the Robinson plaintiffs failed to prove their S2 case or Section 2 case. On the first Jingles precognition, the Robinson plaintiffs did not meet their burden because they did not provide an illustrative map that met all of the state's non-racial goals, including the state's political goals. So that was the first precognition that I said, that they needed to provide an illustrative map. For the second and third, the Robinson plaintiffs offered evidence that black and white voters consistently supported different candidates, but their analysis did not control for partisan preferences. So basically, for this test to pass and them to strike down a district, they have to provide evidence, like current evidence, that they partisan preferences are not different. So African Americans, or in this case black and white voters, need to not have their vote based on race. It basically means that white voters need to vote a lot more with the other party. It needs to be not too much of a difference in their partisan splits for them to rule, which is going to make a very difficult test in any southern state that they're going to be applying it to. This is basically going to prevent the Supreme Court, at least under this ruling and under they're going to be continuing with this ruling. It's going to make it very unlikely that they are going to be striking down any districts here that we're going to be seeing for the future. And if we move down to some of the here, the dissenting, this is where you saw some of the fiery language. um, some of the first things you can notice: state legislatures decides to eliminate the circle district, slicing it into 6 pie pieces and allocating 1 to each of the 6 new solidly white congressional districts. So this is why the second district was originally put into place, is it was split into 6 pie pieces and split among majority white districts. That is why the second district was created. They argue that this is racial vote dilution in its most classic form. And they're saying that it is cracked. Basically, by cracking, you split a partisan district or a racial district several different ways to sort of dilute the power of the original district there. That is their argument. They're arguing that, of course, Section 2 violates that. And that this court is constructed it too narrowly. So they're saying that Section 2 was too narrow, and that they're revising it, and that it is making it quite difficult to prove that test. There you go. They view is under the court's new view of Section 2, a state can, without legal consequence, systematically dilute minority citizens' voting power, and that the majority does not announce today's holding that way. So they're actually claiming that the majority is in bad faith in their holding, that they didn't actually explain exactly what they're doing. They were just explaining why they're ruling, but they weren't actually explaining the consequences, and of course, what's going to be occurring because of their opinion there. So this is fiery language from the 3 liberal justices in this dissent. See, this part breaks down what I was talking about earlier, where for one of their their proofs, I guess. First facts say that in a given area, black voters mainly support Democrats and white voters Republicans. So this is like the South's sort of composition, where you have states that are maybe 35% black that highly support the Democrat, and then you have very polarized white voters, not like what you see in other states, where white voters will vote a lot more liberally. You have very polarized, very conservative white uh, voters in the South. Was viewed today as practically as an element of a vote delusion claim because it indicates that a minority group is politically cohesive enough to elect a preferred candidate, but will be outvoted by the majority bloc. The second fact, the result of a prior mistake by a court is something every day to regret. Not to use an excuse for stripping minority citizens of their voting blocks. So they're criticizing the original VRA Section 2, but they're saying it should not be used as an excuse to strip minority citizens of their voting rights, as they explain. To explaining their test, a plaintiff cannot prevail by showing that a redistricting resulted in the delusion of a minority voting power. But under this new sort of test that they said, rather a plaintiff will have to show, contrary to Section 2's clear text and design, that the legislators were motivated by a discriminatory purpose. So there's in the 6-3 ruling now, to determine a district that is majority minority, in order to have one instated, or to have, as the liberal justices and Democrats might view it, a racial gerrymander, they'd have to prove that the legislators were motivated by a discriminatory purpose, which is impossible in a southern state. That being, as mentioned, the very partisan nature of white voters and black voters in the South. They could always just claim it was partisan gerrymandering, and that basically annihilates Section 2 of the VRA without actually declaring it unlawful. It's going to make things very difficult for any sort of Democrat to win a case in terms of racial gerrymandering in the South. And this is the area that is mostly going to be affecting. This is the first district. This is the Louisiana district that was in question. This one right here. While it is safe, it is probably going to get redistricted, as this case demands it to. They declared this district to be unconstitutional. Another district that might be on the chopping block here would be Alabama 2. This is another similar district, as well as this Georgia 2 district. South Carolina might be this district, and Florida recently actually redistricted, so that is just going to be a whole nother conversation here. So you can see there are several districts that may be on the chopping block, up to 13. However, even if Republicans are managing to shift all these seats to their own, to redistrict in all these seats, even past legal battles and all that's going to happen, they're still unlikely to take the House. And that is even piled on by some Republicans refusing to act. The Alabama governor, in fact, said that they are not going to be redistricting. The governor, Kay Ivey, said the state is not in a position to have a special session at the time, and that means that they're unlikely to redistrict the district that I called out before, Alabama 2. Tennessee said that they are in fact going to look into changing the districts. However, their geography is going to make that a little more difficult here. It's going to be difficult to split off this district, Tennessee 9. So while this is a ruling that is definitely going to be disappointing, and obviously so to of course, anyone who supports um, fair representation in the House, um, this is a disappointing result and a disappointing day, especially to those who are likely going to lose their representation in some of these southern states here. There are going to be people that are going to be uh, disenfranchised. This is the same argument that I always stated with Prop 50, is that it doesn't matter how you're voting. You have to recognize that you are going to be diluting voters' power with these uh, decisions. With Prop 50, you saw it in Virginia. You saw it in Florida when they passed it through their legislator. They did not have any sort of referendum or proposition in Florida. They just rammed it through their legislator, and now it's on Governor DeSantis's desk. Um, these decisions are going to be uh, taking away people's representation. These are areas that were, of course, represented by a Democrat. We'll see if that is going to continue for the future, um, which is I would say is a tragedy. This whole sort of situation has been a tragedy with this new map in Virginia and the new map in California. This one wasn't any sort of thing. This was actually a striking down of a gerrymander. That's why Democrats likely gained this seat as a whole. Um, Redistricting efforts in, of course, you saw in Indiana or in Illinois, Ohio. It's just a tragedy that this is what politics has come down to, is taking these small wins in fact taking away voters representation as a whole. And this even could extend down to protect, because there are some highly Hispanic districts here in Texas that could be now challenged by Republicans in the state. Um, and it is certainly a tragedy for those who are going to be losing their representation in Congress here. Um, so, if you're a Republican, you could see this as a win in terms of gaining districts, and Democrats as a loss. But either party should recognize the tragedy that comes from Prop 50 and this referendum, and Republicans ramming bills through their legislator in Ohio and Missouri and Florida. Um, that there are people who are losing out on representation. Um, so I'd like to thank you guys for watching this video. I'd like to apologize. I am not a legal expert. So feel free to correct me in the comments if I was incorrect in any of my descriptions of what I was talking about in for the actual. I just wanted to actually show what the real, not just focus on what newspapers say, but actually focus on the words of the justices. So I apologize if some of that wasn't as clear as it could have been. But I'd like to thank you guys for watching this video, and I hope you have a fantastic rest of your day.